recurring colleague, Damian Schiff, but he is at the moment on a client call that is running long. But we wanted to get started and talking to you about everything that's happening at the Supreme Court. Oh, look at that. He's already ready to come in. We waited forever, and then right when we start, Damian decides to grace us with his presence. So welcome, Damian.
I wanted to increase the dramatic effect of my participation.
Well, there's been a lot that's been going on at the Supreme Court. We're going to start with talking about PLF's argument from last week. That was Pung, where PLF was before the Supreme Court. Then we're going to move on to some of the opinions and orders and opinions related to orders that have come out in the past week, and then we'll conclude with a recap of the three cases that the Supreme Court heard argument on this week. So let's start with Pung, PLF's 21st case before the United States Supreme Court, involving a tax foreclosure sale in Michigan, where a property assessed for $100,000 was sold for a fraction of that. The proceeds or the excess equity from the sale was returned to the client, but there was this huge gap between what was quote unquote the fair market value and what the property sold for. So our client argues that this was a taking or an excessive fine under the Fifth and Eighth Amendments. Let's start with you, Damian. What did you think of the argument? What did you think of the justices' response to our arguments?
The argument I did not listen to. I read the transcript, and so this might be an interesting comparison or example of how there is a difference in how the argument is perceived based upon how you digest it. But just from the transcript, I thought that Mr. Pung's counsel, Mr. Ellison, did a very fine job. I think the court is clearly dissatisfied with the Sixth Circuit's approach, which was that necessarily anything that comes out of an auction is going to satisfy just compensation. It didn't seem like really there were any votes for that rule. The question in my mind is whether the court will lay down a rule to say, well, what does an auction have to do in order to satisfy just compensation, or whether it'll just suggest certain things that are likely required and then allow the lower courts to continue to develop the law of what is just compensation from an auction sale. But I don't think that the court is going to fully accept the argument that we had hoped the court would accept, which is the auction is really neither here nor there, that what matters is just compensation, that just compensation is fair market value, and that if an auction happens to produce fair market value, great. But if it doesn't, then the government still owes the difference between fair market value and the auction. It just seemed like there was really no support for that, and so the question then becomes, well, how much of a difference between fair market value and auction value will the justices tolerate?
Yeah, I should add that Mr. Ellison, I think, was his first argument before the court. He's not a PLF employee. We joined him on the case after cert was granted. Given our expertise in this issue, we've litigated a lot of home equity theft cases nationwide and in Michigan. And so, it came across, I think, that he's certainly a practitioner. He's not an appellate attorney, and your reading of the transcript, I thought, given that he's not Paul Clement, I thought it was a little bit shaky at first, but then he sort of hit his stride. There were times when I thought the justices were sort of arguing against each other, which sometimes can be a signal of the advocate not sort of commanding the answers that the justices are looking for. However, I thought, as the argument went on, he really got his sea legs. He remembered sort of the points that he wanted to make, and I thought his rebuttal was really strong. It was really heavy on the equities, Now I've come to learn that maybe some of the PLFers that were in the courtroom with him were suggesting different answers to some questions, but I thought he did a really stand-up job for where he was, and with the bright lights of the Supreme Court on him. Oliver, what is your sort of sense of the argument, sort of writ large, from what Damien says? Do you think there's any hope for sort of the fair market value position, or do you think we're screwed on that?
Well, first, I just want to say I'm not at all offended that I was ready 25 minutes ago, but you let Damien talk first as soon as he showed up. I agree, and one thing I thought that Mr. Ellison did well, by the way, was he was able to answer the justices' questions about the whole process in Michigan. They asked him, how did it get this far? Why are we here over a $2,000 debt when the home is worth somewhere around $190,000? And he walked him through why this process is the way it is. I agree with Damien. I think that there certainly won't be a rule that says fair market value must be, or just compensation requires fair market value. And on the other side, there's certainly, court's certainly not going to hold that any kind of the result of any kind of auction constitutes just compensation. So where will the justices find themselves? The difficulty, I think, is that as much as they don't want to say just compensation requires fair market value, there's no way around the fact that courts are going to have to get a number. And how they do that, whether it's through expert testimony or whatever, even if they don't say that an auction isn't required, or it doesn't matter what the auction says, at some point they're going to have to get into that. And so maybe they're just kicking the can down the road. Mm-hmm. But at some point the courts are going to have to figure out how, when there's an auction, how they're going to figure out what the fair market value or what the just compensation is.
If I could add, sorry, Mr. Thompson.
Go for it.
Just quickly add, one thing that I think some of our listeners might not be aware of is that the United States filed an amicus brief and had argument time and supported reversal of the judgment, but really articulated kind of a middle ground, and I think that middle ground had a lot of influence on some of the justices. In fact, Justice Kavanaugh in particular asked the assistant to the Solicitor General about the various guideposts that their brief discussed for how to ensure the fairness of an auction, which the government then, the U.S. would then argue would be satisfactory of just compensation. Yeah. And so I think that if the U.S. had not participated, I think maybe there would have been perhaps a different approach by the court. But I think especially where the U.S. can talk about, well, the IRS regularly conducts these foreclosure sales, and I think there's a concern for some of the justices that a strict fair market value rule might be too disruptive of the of the property tax foreclosure system.
Mm-hmm. I was going to say, I thought, I don't remember what I was going to say. Oliver, you had something to say.
Well, I was going to say that the Justice Alito and Justice Jackson, at least, and maybe Justice Kavanaugh, were concerned about blowing up the way courts have done, the way the counties have done this forever. And one response I was thinking of is, well, the court just said a few years ago that home equity theft is unconstitutional, which is to say that before, whenever Tyler was issued,
2023, I think.
Yeah, it's very recent. So before then, counties could take homes worth far more than the tax debt owed, and could auction them off and keep whatever they got. Now, of course, the counties or the governments in those situations would have the incentive to get as much as possible. But at the same time, if it's a $5,000 debt and you're getting $100,000, how much more effort are they going to put into it to get $120,000? So the notion that the only way to do this is to look at history and tradition in this context. Just I thought didn't make sense because it's a brand new, in some sense, constitutional right or a newly articulated constitutional right.
And a right that's available in a procedure for the first time in a long time.
Right.
Well, and one thing that I think we discussed in our show leading up to the argument is, I think it's relevant that the county here had a lot of other means of getting its debt paid than the tax foreclosure route. And to me, that I think should be relevant to the just compensation analysis. It's obviously not relevant to how the auction is conducted, but the necessity of the auction, I think, is relevant. And, even like Justice Jackson was taking the position that, well, if it's just compensation, doesn't that imply some sort of clean hands or culpability analysis? Well, that should cut both ways. I mean, if we are going to introduce those factors into the analysis, isn't the county guilty of being excessively zealous?
That was a ridiculous suggestion by Justice Jackson. She's been on my good side lately. That was atrocious. That if you owe a tax debt plus interest plus penalties, that somehow you're entitled to less compensation. That's just ridiculous.
Yeah, she was very much on the side of, well, let's start with where the wrongdoer is. This person didn't pay his taxes, and that's the original wrong that started all this. It's like, but like that's all anyway. The 2 points that I wanted to say is in response to sort of the U.S. as amici. I thought Justice Gorsuch had the line of the day. I don't remember exactly. He said like, you want some of your coulis, but if you're going to take, you have to eat all of your coulis. I forget exactly what it was, but he was sort of responding to a few of the historical points that the United States was making with a response that they're ignoring a lot of the other responses. And I remember leading up to this case, and of the three of us, I'm certainly the least knowledgeable of the facts, having not been involved in any of the moot courts. But it sort of struck me originally that this sounded a lot in due process, especially where the argument was going with like Michigan's particularly wonky, particularly nefarious, and that therefore it would be a violation. But after hearing the argument, I sort of see like the fact that the processes here were so skewed towards disenfranchising the pungs of their property and their equity does go towards the justness of just compensation, right? So you can see a scenario where the procedures and what's happening is a question of just compensation, because if everything is perfectly followed and the bidding just doesn't get to fair market value, I think it's hard to say that it's not just at that point. Anyway, the last question I guess I have for either of you, this case was granted on 2 QPs. I don't recall any discussion or very little discussion of the excessive fines clause. Any chance the court opines on it?
No, I think Mr. Ellison mentioned it once or twice in as a just kind of a throwaway. But no, I don't see any chance they get to the excessive fines question.
Yeah, I agree.
I mean, yeah, I guess, which means though that we're going to get a win, because if it were a loss, then they would have to reach the excessive fines clause, right?
Yeah.
Yeah, I think that's right too. Yeah.
Yeah. Any other final thoughts on Pung from either of you?
Just, I would note that several of the justices had a lot of questions about the facts of the case, and noting how they thought how egregious they were, how Mr. Pung was terribly mistreated by the county. And I think that goes to show you why they took this case. I mean, it reinforces the importance of having good facts in public interest cases.
Yep, very much. Let's move on to some of the opinions that have come down. We'll start first with the emergency docket before we move to the actual opinions. Oliver, talk to us about the Melionakis decisions or opinions. This is a case dealing with redistricting in New York State. We've seen a number of these come to the court this term, California famously enacted a new proposition that did away with its independent redistricting commission so that it could gerrymander 5 more Democrat districts, and the Republicans in Texas did the same. I think it's going on in Virginia. I think Indiana is the only one that sort of rebuked the parties, but something similar in New York, but a different result in this case.
Yeah, in this case, the court granted a stay, and it was a stay of a New York State trial court, which ordered the New York Independent Redistricting Commission to draw a new congressional district this is according to Justice Alito, for the express purpose of ensuring that minority voters are able to elect the candidate of their choice. And so that was, by the way, the order itself is a paragraph. And then Justice Alito's opinion is about 3 pages explaining why he thinks the stay was correct. And Justice Sotomayor, joined by Justices Kagan and Jackson, thought the stay should be denied. And their point was that the court has often said that the federal courts should not get involved in state election issues close to election day. And they said that now the court is violating what it said in other cases and suggesting that this would, I guess, support or help the Republicans in New York. And so another shadow docket controversy.
Yeah, I'll say, like, when we were talking about the Texas case, and that redistricting was originally stayed by the 3-judge panel, the Supreme Court stayed that ruling. And then I had come on here and said, yeah, that makes sense. They think this is all political. They're going to do the same in California. So when the Republicans brought suit challenging the California's redistricting, I was right, and they let that redistricting go forward. And so when I first read that this stay was I thought I had read that the stay would allow the redistricting to go into effect. I only skimmed it. But that's not right. They actually prevented this redistricting to go into effect, although it seems like it's ordered by the court as opposed to some political process. Yes. What I will say is different here from my only brief reading of the opinion is that it is doing it for the express purpose of race, and that they're saying that minority voters need to be able to elect a quote unquote candidate of their choice, which frankly comes directly from the text of the Voting Rights Act. So, but the Voting Rights Act is, I think, in that respect, very clearly race conscious and race based. So I sort of read the court to be saying here, and I think we have a voting rights case that we're waiting on a decision from, that there is some real concern that expressly writing into the statute that minority voters ought to have the right to elect candidates of their choice is discriminatory on its face and ought to be declared unconstitutional.
And I don't know, again, I don't know much more than you do, but in the previous cases, I think those were statewide maps. And in this case, it was the redrawing of one district. Now, obviously, other districts would be affected, but it wasn't a statewide map that was at issue, which I suppose it's easier to argue that when you're redoing the state, it's more of a political enterprise than trying to create a minority district or a district where minority voters can select the candidates of their choice.
Yeah. There's a pretty howdy dissent from Justice Sotomayor in this case, where she calls the court across the carpet for what she views as flip-flopping based on the result. You know, I think that's hard to reconcile with the fact that they let the California statewide redistricting go on without so much as a whimper. But be that as it may, that it's her opinion. Any other thoughts on this voting rights case, Damien?
No further thoughts.
How about, Damien, can you talk at all about Mirabelli, the case out of California? Now, this was also an emergency docket case. However, the court did issue a per curiam opinion.
Yes, I have even fewer thoughts on this one than I didn't know. But as I understand it, it's a religious liberty case. Parents who are objecting to California law that prevents public school officials from informing the parents that their children are being referred to by the pronouns of the opposite gender, or they're otherwise acting as transgendered kids while they are at school and being treated as such. And the plaintiff's class of parents made religious objections to the California law that prevented them from being informed of this. And as I understand it, the Ninth Circuit stayed the district court injunction that would have prevented the parents, or the injunction that prevented the state law from preventing the parents from finding this stuff out. And then the Supreme Court essentially stayed the stay, and through a per curiam decision, but there was a sort of supporting rationale provided by Justice Barrett, and then a dissent from, kind of a mild dissent, I guess, from Justice Kagan. Mild because it even seemed like she was suggesting that, yeah, there probably is a religious liberty problem here. The concurrence from Justice Barrett is interesting because it talks about substantive due process. And this is responding to Justice Kagan's argument that, wait, I thought, Dobbs got rid of substantive due process. Now you're relying upon it because it's just happening to support a particular policy that you approve of. And I think Justice Barrett did a good job of saying, well, no, Dobbs didn't say we're getting rid of substantive due process. Dobbs just simply said that whether you like it or not, the substantive due process rule requires that a right be, sort of firmly established in the history and culture of the people, blah, blah, blah. And that abortion in that case didn't meet that test, but that here we're talking about parental rights, which have met that test in many cases. So for the majority, there's no inconsistency, and I think that seems satisfying to me. I mean, I don't see a conflict. Now, I think Justice Kagan also said, well, now wait a second, we just had a case called Skermeti, where it seemed like we weren't willing to give a very high scrutiny to a law that seemed to burden the ability of young people to change genders. And isn't that inconsistent? And I think there again you can say, well, no, not really, because there it was just, as the court explained, medical practice. Here, though, we're talking about a direct limitation on the ability of parents to know what their children are doing at school. So I think even there's a distinction. But certainly one could say superficially there are inconsistencies, and I can see why Justice Kagan might be concerned about that. But again, bottom line is, even in her dissent, she seems to be suggesting that, yeah, they probably would get some relief ultimately on the merits anyway, that California's law is burdensome of religious exercise, and that it's not narrowly tailored, and that should be it under strict scrutiny.
So it sounds like you actually do have a lot to say about this case. I don't have much to add. I think certainly as someone who has litigated and plans on litigating future substantive due process cases, it was nice to see the court, because the court also rules on substantive due process grounds, the per curiam opinion, and cites Pierce and Meyer for the parental rights aspect of it. It's nice to see that from the court, that where it's certainly not clear, and you've heard more than one time Justice Gorsuch poo-poo the idea of substantive due process. So that was nice to see. And I will say this is I think a real problem. It may sound a little bit crazy it certainly sounds crazy to me that a school district would not tell the parents when they are transitioning the parent's child. I mean, it sounds crazy to me that the parents would be kept in the black. But as PLF Supreme Court show superfan Dan Lennington of Wisconsin Institute for Law and Liberty has noted, both in Twitter and elsewhere, there are a lot of school districts that do this. That their policy is to not tell parents when they themselves decide to allow for or help transition a child, and seems like that would implicate a parent's fundamental right to me.
I just offer one point. The as Damien said, it's a convoluted procedure here, but the before the court was an application to vacate the Court of Appeals order staying a permanent injunction. But the main point is that there was a permanent injunction. So a district court got to the merits. This wasn't a preliminary injunction, it was a permanent injunction. And then the Court of Appeals steps in and says, no, we're going to put that on hold. And so all the Supreme Court did here was allow a final order from the district court to stay in place, which is not crazy. In the normal, we filed, and we don't file so many anymore, but we've filed a number of motions for preliminary injunction, and we often lose because the court says, well, you can't meet the 4 standards. And here the Court of Appeals says, well, close enough. We'll put a stay on a permanent injunction. This one bothers me less than or to the extent any of them do, that this is an emergency docket case. This one doesn't seem to rise to the level of problematic.
Your explanation there, I couldn't agree more. It reminds me of a case that I litigated called Coalition for TJ, where we won a summary judgment before the district court in Eastern District of Virginia. The school district sought an immediate stay from the Fourth Circuit, which was granted. The stay of the permanent injunction was granted. We then sought review from the Supreme Court to lift that stay, and we were not afforded that relief, although I will say 3 of the justices, I think Alito, Thomas, and Gorsuch, would have granted the relief that we requested. It's kind of ridiculous. If you get summary judgment and a permanent injunction based on the full record is entered, that they can then meet the factors for immediate emergency stay. I share your lack of outrage for that.
And one thing I was talking the other day about Congress, or the Supreme Court takes so few cases nowadays. One potential idea is to allow for some period of an automatic stay to prevent parties going to the Supreme Court so often with these emergency motions. It might free up the court's time to take more cases. I don't know if it's realistic, and I don't know how you put limits on that, but just an idea.
I'll mention one other opinion that came down. It was from Justice Kagan in a denial of, it was a dissent to a denial for cert. This case dealt with whether prisoners can pool their civil docketing fee. And I guess there's a split of the courts, and she wrote an opinion saying that the court should have taken that case. I don't know, there's a whole lot to say there. Any thoughts on the civil docketing fee issue, Mr. Schiff?
Is this what would be waived if they proceed
Yeah, and to be frank, I saw that came up in the opinion, although I didn't read it close enough to recognize why that wasn't an issue. But what I understand is that there are multiple prisoners trying to pool their resources in order to pay the fee, and I guess it was not allowed in this circuit. But it seems to be a genuine circuit split, according to Justice Kagan.
Oh, this is just a notice of appeal fee?
No, well, now you're going to make me look it up.
That's
No,
that's fine.
well, I'm not going to do that now. Maybe while we're talking about something else, I can
All right.
look at it. But let's move on to the opinions of the court on actually argued cases. We had 2 unanimous opinions, which not that uncommon from the Supreme Court to issue unanimous opinions, despite all of the rhetoric outside the court of it being so polarized. Which of these do you want to talk about, Oliver? Gillette or Urias Oriena?
I will talk about Gillette. That was a Gillette sued the New Jersey Transit Corporation for a tort. And the question was whether the Transit Corporation was immune because arguably it was a branch or arm of the New Jersey state government. And there were suits brought in New York and Pennsylvania And one court said that the transit authority was immune because it was a branch of the New Jersey government. The other court said the opposite. And as you say, it was a unanimous opinion by Justice Sotomayor, and they concluded that the Transportation Corporation is not an arm of the New Jersey state government. It went through that the state set it up as a legally separate entity. It is responsible for its own bills, even though the state often, and it sounds like very often, comes in
exclusively.
Yeah, it comes in and pays their bills and pays their liabilities. But nonetheless, the court said that it was a separate entity. One interesting thing, this is going back to the shadow docket. I saw this on
Emergency docket.
Emergency docket. Professor Josh Blackman pointed this out, that a stay had been put in this case earlier, but the court ruled the other way. So even though the court found that there may be irreparable harm, it didn't. It sounded like this is a unanimous opinion. So it's hard to believe that the court thought that the challengers, or that there was a likelihood of success on the merits by whoever sought to stay. So it's an interesting point that sometimes.
Well, I didn't read.
Yeah,
I didn't read Blackman's opinion, but I think that the stay was it. So there were two torts. I think a bus hit a guy in New York State, and the New York guy who got hit by the bus from the New Jersey bus sued New Jersey and New York, and the court stayed the actual trial, I think, from going forward.
Correct.
So I mean, you could say, like, depending on how they rule, there may not be the need for a trial. Now,
well, that's always the case. That's always the case. That's always happens. We always say we shouldn't have to go through with this if we're right, and they say, "Too bad."
Fair enough.
I will, if I may say that the winner here, Mr. Gillette, was represented by Michael Kimberly, who is a SCOTUS litigator whom I've had the pleasure of serving on a couple of panels with, and who also was a moot court judge for me for one of the Sackett cases, and I'm glad to see that he secured a win here, which I think...
Humble brag.
I was going to say, it's nice for Damien to show up 40 minutes late and name drop. Go ahead.
No, but I mean, it... although I don't know if you fellows had the same experience in reading Justice Sotomayor's opinion here, but it's hard to come up with a hard and clear rule, right? I mean, she talks about a lot of different factors, like the corporate form is important. It's also
I think that's it. It's the corporate form. That's the only thing. Because all of the control and all the other factors.
She talks about a lot of other things
other
than corporate form. She talks about, how it's referred to in state law, whether it can be sued or be sued, like or the real party and interest rule, whether, if in fact the state is really the proper defendant, it doesn't, anyway.
Yeah.
I agree. I mean, the only thing that really seems unique about this and why immunity doesn't attach is because of, I would say, how it's created and the form. I think all of the other factors cut the other way, and a lot of them, I think, cut in favor of it actually being entitled to being an arm of the state. Now, I hate immunity as much as the next libertarian, but at least being classified as an arm of the state, I think there's a lot of evidence that it ought to be, other than how it was created.
Yeah.
Well, also, too, this New Jersey could just by statute immunize it, right? Yeah. So this is really just a sort of a question of what's the default rule.
Yeah. Yes. Did I have any other thoughts on that case? I don't think so.
I think we should also just say, too, sovereign immunity, of course, as you were saying, is not one of our favorite doctrines here. And I think this is good. I think this does show a reluctance of the court to treat that doctrine aggressively. Sometimes in federalism it's popped up, but it's good to see the court here not wanting to extend it farther than absolutely necessary.
Yeah. Damien, can you talk about the other opinion that came down, the Urias or Oriana?
Yeah, in fact, actually, I think this was one of the cases that I treated briefly before the argument, and its significance is essentially an immigration law case, because it deals with the standard of review that the Court of Appeals applies when reviewing a BIA or ALJ determination under the BIA of an asylum applicant's assertion that he or she would experience persecution if he or she were deported to a certain country. And the argument from petitioners is that that persecution finding is either a legal question or it's a mixed question, and it should be subject to more or less de novo review in the Court of Appeals, whereas a lot of Court of Appeals have held that it's substantial evidence review. And the opinion, I think it was Justice Jackson, I believe the opinion kind of takes the absolute shortest route possible to rejecting the attack on substantial evidence review by saying, well, we've kind of already decided this issue in a prior immigration decision where we said that the entire persecution decision, however you characterize it as, purely legal, purely factual, mixed, doesn't matter. We've already decided that as a statutory matter, Congress has said you have to review this according to substantial evidence. I'll note for Oliver, there's a footnote where the court says, we do note the petitioner's argument that Loper-Bright requires us now to review this decision de novo, and the court says we don't have to address that because even Loper-Bright said that our rule of no deference to agencies for legal interpretations doesn't apply where the statute has constitutionally granted discretion or where the statute says a particular standard review is to apply. So again, here the court said that Congress through the INA has said that it's substantial evidence review.
Yeah, I didn't have a whole lot of comments on this one. It seemed pretty straightforward. Any thoughts, Oliver?
Nope.
Well, thank you, Damien. Let's move on to the three cases argued this week, and I think the most interesting one is United States versus Hamani. Am I pronouncing that right? And what's this case about, Oliver?
This case is a gun control case, Second Amendment case. There's a federal statute that prohibits the possession of a firearm by someone who is an unlawful user of or addicted to any controlled substance. In this case, I think he was an Iranian national or a dual citizen, United States and Iran. And I forget how he got on the feds notice. They showed up with a warrant. They found a gun. He apparently admitted, I don't know how this came out, but he admitted that he used marijuana regularly. I think it was about like once a week. And the court also found some cocaine in his mother's closet, and he admitted it was his, and that his mom took it from him and apparently didn't flush it down the toilet. But in any event, he admitted that it was his. And so the question is whether his admission basically that he was a regular user of marijuana was sufficient. And there is an argument, there were disputes about the distinction between an unlawful user of, and someone who was addicted. And the case was argued on behalf of the petitioner. He was convicted, so he's appealed. The petitioner was represented by Erin Murphy from Clement and Murphy. And her argument was that under the Bruin test, which is the Supreme Court's case from a few years ago, which says that there has to be a historical, a history at the founding of this type of regulation to satisfy the Second Amendment. And she argued no, that in this case this type of regulation didn't or it wasn't around at the founding, and therefore the Second Amendment precludes the conviction here.
Yeah, and she actually won in the court below.
I'm sorry. Yes, petitioner was the government. Yes,
petitioner was the government. So let me add a little bit more meat on that just for our listeners. It was the question is whether he can be sort of like permanently deprived of his Second Amendment right to carry a weapon because he admits to, I think it was 2 times a week smoking marijuana, and whether that and so under Bruin, it sort of becomes a question. I think both sides would agree to this. Is there a historical analog that at the founding that would have allowed for disarming individuals of their or taking away individuals' Second Amendment rights that can be conscripted to apply to this scenario. And what the government said was the analog were sort of public drunkenness laws. And there's a great line, I think it's by Justice Gorsuch, when he talks about the different drinking habits of the founders, something that will make Damien even blush, I think. What was it like? Like John Adams would drink a tankard of cider in the morning, and I forget who else would do something.
Jefferson didn't drink too much, only 3 or 4 glasses of wine a night.
Yeah, exactly. And there was a third one, and these guys were not considered even remotely thought to be publicly drunken to be disarmed. So there was a lot of questioning about it. I mean, it's rhetorically funny, but it's also very important to the Bruin point of whether these laws. So I guess the government's argument was what these laws show is that they wanted to say that this is significantly analogous to illegal drugs, and because it was illegal, I guess, legality to be drunk that much, it's now you're being intoxicated by marijuana. Even if it was like one time, I guess that would be sufficient. Whether that's a good enough historical analog. So
and the government said that those early laws show that there can be categorical, that the government can make categorical categories of people who cannot possess arms. And part of the problem was that this is marijuana, and we don't know how much. And the government tried to rely on the various schedule of unlawful drugs, and said very firmly, yes, if it's on the scheduled list, if it's one of the illegal drugs, then it applies. But she tried to walk it back and say, well, okay, but definitely for Schedule 1 and Schedule 2 drugs. And if you want to draw a line after that, then we understand maybe you can get into more of a individualized test to determine whether this particular person is intoxicated sufficiently or often enough that he should have his guns taken away, or that the drug is dangerous such that regular use of it would impair you, and therefore the categorical ban can apply.
Yeah, I think the government was having a hard time distinguishing between, say, marijuana, cocaine, methamphetamine, and things like Ambien, or even Ritalin.
Robitussin.
Robitussin was one that they threw. And the government's position, the government's frontline position, that's the new thing. The frontline position is all of this. You can disarm people for using Robitussin without a prescription. I think, I don't know if it was in this argument or the next argument, the Chief Justice said, when I hear someone say frontline position, I immediately makes me think that you're ready to retreat. That was spot on. So I'm so sick of our frontline position being the rhetorical device of du jour. So that was the really hard part for the government. The government didn't really, I don't think, have any decent responses to that. Not least of which, like, marijuana is legal in 40 states or something like that, and the president is declassified. So, which is what Ms. Murphy pointed out. And I think, I don't think she had difficulty answering these questions. I will say I thought Ms. Murphy was fantastic. I'm like, I actually was thinking about it. I'm like, that's as good of an argument as I can remember. And then I looked it up and like, oh, she's with Clement. Okay, well.
Yeah. So she's still only the second best oral advocate in the firm.
But she was really, really, really great, I thought.
Yep.
I don't think she had a hard time responding to it seemed like Justice Alito was really hung up on these ideas of individualized consideration, that you're going to have to do all these individualized fact-finding. And her response, I thought, was spot on, that the government already has to do this if they're going to commit. You already have to show some anyway. And that the drug classifications themselves already go through a lot of this. So it's not like you're adding a whole big burden to the government. But Justice Alito really wasn't buying it. He was so clearly in favor of the government's position that you can create these broad categories. The last thing I'll say, we've been talking here for a while. I don't know. I have a little bit of sympathy for Justice Jackson's repeated skepticism of the Bruin test. She's like, we just had this Hawaii case where we're trying to say that these things are sufficiently analogous, and now we're on the other side of these other things are sufficiently analogous.
And the government was on. She pointed out that I think it was Harris who did the argument for the SG today. Was the lawyer arguing in that Hawaii case a month ago? So yeah, go ahead.
Yeah. So the whole idea of Bruin is to sort of be able to anchor to something objective in the historical record. But if we're just sort of like extrapolating certain causes of action and trying to graft them onto modern causes of action, there's sort of the inherent arbitrariness of that. Why don't we just go back to means end scrutiny? And I think she has a point. I mean, I think means end scrutiny is probably worse on that score, but it doesn't mean that the Bruin test is solving all the problems either.
No, I agree. She was good with her questions on. It seems like both lawyers a little bit were arguing means end fit, and trying to mask a means end fit analysis under the Bruin test.
Damien, we've bogarted most of the time on this case. Do you have any other thoughts?
I have nothing to add.
All right, well then we'll turn to you for the case argued yesterday, Hunter versus U.S.
I have even less to add there.
You said that last time, and then you proceeded to wax
No,
eloquently.
it's some obscure criminal law thing. I'm not.
I can introduce it at least. The issue is a defendant entered a plea bargain and agreed to waive appeal, and then at sentencing, it turned out that, and he had told the sentencing officer, whoever does the sentencing recommendation for the judge, that he had some anxiety as a child, and so the district court judge said that he had to take whatever medications the doctor would prescribe. And then the judge said, if you work with your probation officer, that comes out to be a problem, you can appeal. Then he asked the government lawyer, anything to add? And the government lawyer stumbled a little bit, but ultimately said no. And then he wanted to appeal that sentence, taking the medicine. He didn't have objections to anything else, but he thought the order to take medicine was too far, a constitutional violation. And it was an appeal in the Fifth Circuit. And the Fifth Circuit said that there are only two exceptions allowed to an agreement to waive your appeal. One of them is claims for ineffective assistance of counsel, and the second is if the sentence exceeded the statutory maximum. And so the first question presented by Lisa Blatt on behalf of the petitioner is whether those are the only permissible exceptions to a waiver of an appeal. And she pointed out that other circuit courts allow more exceptions. And then there was a second question presented. That was her frontline question presented. Her backup was whether the waiver applies when a sentencing judge advises the defendant that he has a right to appeal and the government does not object. And I don't think any of the justices were willing to go along with that second one. But there's a lot of discussion about the first question.
Yeah. Essentially, can you waive your right to appeal, even if like a condition imposed is sort of beyond the pale? Is sort of where I felt the argument went. There's a lot of it delved into contract law. Ms. Blatt argued that this is no different than a contract, so she should have all of the regular contract defenses. I think the government pushed back on that to say that, no, this isn't exactly like a contract, but it felt to me that the court was not comfortable with the government's frontline position of they can, which I actually had some sympathy for the advocate for the government here, even though I didn't think she did a great job. I mean, she's going up against Lisa Blatt, but I mean, her argument was to the court, you're sort of looking at the wrong thing. You're looking at the condition imposed, like if it was a racist judge or if there was some other unconscionable condition, like there was a castration, I think was one of the examples that they threw out there. But what you should actually be looking at is whether the bargained for thing was fraudulent or motivated by race or some other factor. And so here, everybody sort of agrees that what the government and the felon agreed to was perfectly above board. They agreed to a sentence, a plea bargain, and as part of that agreed plea, he would waive his right to appeal, all above board. And then the judge sort of went rogue and imposed this medication requirement. And her point is like, that can't be on us. We bargained in good faith. He knew that the judge was going to impose a sentence. That's not on us. That's what everybody knew ahead of time. You can't appeal that because then we're losing the benefit of our bargain. The whole reason we wanted to engage in the plea is so we wouldn't have to worry about an appeal. I'm actually somewhat sympathetic to that.
Yeah, and she
In terms
also
of I mean, sorry, but even though I don't know what was going on, I can at least say that you can say, well, what you bargained for is no appeal over your stuff. But isn't the whole objection here that, well, this provision, this extraneous medication provision, it was not your stuff, it was the judge's stuff. Mm-hmm. So your consideration has not been violated. You're the government, meaning that he's not trying to appeal the things that you were hoping to get him not to appeal about through the waiver of his right to appeal.
Yeah, and the government's lawyer also made the point that, again, the condition was legal, that a district court judge will do the sentencing. Justice Gorsuch brought up the point, apparently based on a Judge Posner decision, where he said that you can't have 12 orangutans issue a sentence. And she said, well, yeah, but that's an unlawful sentence. If a court could do it, you bargained for a court to make the sentence, and that's what happened. But everyone agreed, I think, even the government's lawyer, that at some point there has to be. You can't just do whatever he wants. The government's lawyer was most concerned that the court just not come up with an amorphous. This is beyond the pale of, as you said earlier. She wants it to be more strict. In fact, her frontline position was that there should be nothing. She wanted to get rid of even the Fifth Circuit's two exceptions.
She would say if the judge went rogue and turned out to be racist and imposed a draconian sentence, that tough cookies, because the bargain for appeal right, that was all in good faith. Yeah,
and so she said if the court is going to expand upon the Fifth Circuit's exceptions, just to do it in as narrow a way or put some limits on it, so we don't have to re-litigate all these appeals.
Yeah. At one point, in a moment of levity, this is the case where the Chief Justice said, you say this is your frontline position, makes me think you're going to retreat. So then she really tried to dig in her heels, and then it was not going well for her. It's clear that the court is not comfortable with the idea that you would never have an unconscionability defense to something like this, or against public policy or what have you. But then Justice Kagan said, just out of curiosity, what is your fallback position?
That was good. And there was another, I think it was just this argument, but I listened to all three of them today, so I may be wrong. But at one point, Justice Alito was saying that, all right, well, I'm going to ask you a question now, and this will be my rebuttal to Justice Sotomayor's question. But then she gets to do a surrebuttal because of the way we do these questions now, and I don't get a chance to respond or something like that. But I was thinking that was, I think, if I'm right, that was during the petitioner's questioning, so he could have turned Justice Sotomayor's questions around to the other side. But anyway, it was a funny.
It was a little bit of like a dig on this. He said how we do questionings these days. There's a little bit of a dig on sort of the seriatim questioning that the court's instituted.
Definitely.
Let's move to the last case, and I will be honest, I've only listened to about half of this, and this is Paul Clement. Once again before the court. Oliver, what's this case about?
This involves the congressional deregulation of so many industries in the 70s and 80s and into the 90s. And it's the Federal Aviation Administration Authorization Act of 1994 in particular. Bottom line is that Congress deregulated interstate transportation, trucking. And what Clement said is that Congress definitely intended to deregulate or to get rid of economic regulations, but but he said what they definitely didn't want to do was get rid of any health or safety regulations. That was still left up to the states. And in this case, his client was hit by a trucker who had fallen asleep or something, I forget. And his client sued the broker. And brokers are people who, as the name sounds, connects people who need trucks with people who drive trucks. And so they don't actually do any shipping. And so the question is whether this law preempted state law, which allows for a tort in that situation against the broker.
Mm-hmm. Any sense of how the court was going to come down in this case?
Well, there were two sections of the law, and one was directly applicable to this case, one was not, and I forget which is which now. But the section that posed fewer problems is the one that's at issue, and so I think they're going to go with Clement and say Congress did get rid of the economic regulations. It didn't get rid of the health and safety regulations by the states.
Yeah.
And one point that Justice Jackson, I thought, asked the best question, and in fact, she went through this a few paragraphs, and Clement said, I wouldn't change a word of that. And then she came back again and said something, and he said, again, I agree with you completely. And her point was, and by I should give a little bit more background. Justice Kavanaugh and I think Alito were concerned because there would have been a discrepancy. The law, and I forget exactly which is which again, but the law would allow for tort actions against intrastate shippers, but not against interstate shippers, or vice versa. Either way, it doesn't matter. But in other
It
words,
was saying that what it was saying. Since I think this is the big point that Kavanaugh came out of the gate swinging on this point,
Yeah.
and Alito too, that preemption would apply greater to the intrastate people and not the interstate people. And they're like, this doesn't make any sense. Shouldn't federal preemption be more often to interstate?
or at the very least, shouldn't it be the same? He's saying this makes a patchwork. And Clement said, well, that's, it's incongruous, but that's what the law says. But Justice Jackson made a good point. She said in the 70s, you had all kinds of state laws, tort actions, things like that were in place all over the place. Then at some point, the federal government got involved and started regulating everywhere. And then in the 70s, 80s, and 90s, the government said, okay, you know what? We're getting out of the economic regulation business. And all that did is bring back what all the states had originally. And so in that respect, why it's not Congress's job to clean up the different state regimes. And there may be some incongruity here, but the state got out of the way, or I'm sorry, the federal government got out of the economic regulation, and that brings up some strange results between interstate and intrastate and among the states themselves.
Yeah, that is a good point. Last thought I thought on this is I think Alito at one point was also having difficulty with this intrastate-interstate sort of weird result outcome, and he asked Clement, I was hoping you would come here and you'd have some like grandiose idea for reconciling these things, and Clement's like, well, I wish I did too, but it escapes me if it's in there, and he couldn't figure it. But his response was, look, it's just what the text does.
Yeah.
Yeah. Mr. Schiff?
Do you use a hyphen when you spell preempt?
No.
Otherwise, isn't there a risk that you would just say preempt? If you look at older Supreme Court cases, they put a diaresis over the second E to emphasize that the two E's are pronounced distinctly. More recent cases, the style convention has changed to a hyphen.
Either way, one of the two should be used.
No, I would use neither.
Nah. Then you get these ridiculous, like, anti-disestablishmentarianism words that...
Preempt, it's like 7 letters.
Yeah.
No, but the idea is that you're indicating to the reader that you separately pronounce the first two E's. They're not pronounced as preempt, it's preempt.
I get it. I think there are a lot of English words that are not pronounced how they are spelled, and we don't add accent marks in our beautiful language because we're Americans.
Damien just likes what are the two dots called?
The diaresis, right?
Yeah,
And
The
because
diaresis.
older Supreme Court cases have it.
he likes the reference to the heavy metal band Motley Crue.
Damien, do you even know who Motley Crue is?
No, that's my polite laugh.
How is diaresis different than an umlaut?
It's the same. It's the same thing. Just I think it functions differently in English than it does in, or what it symbolizes is different in English than what it symbolizes in other languages.
Fair enough. Well, on that point, we've been going for a solid hour. Any final thoughts, Mr. Schiff, Mr. Dunford?
Nothing.
Exciting week at the Supreme Court. Thank you for joining us. And Oliver put in Motley Crue in our chat here for Damien's enjoyment. I'm sure he was going to go home and listen to Dr. Feelgood and enjoy his crew. All right. Without further ado, thank you for joining me on PLF Supreme Court Show. We'll be back next week. We'll be back next week. We'll have something to talk about. Thank you, guys. And
See ya.
thanks to all of our listeners. See ya.